afternoon, everyone. Nice to see everyone again. Hope that the reading week made all of your dreams come true, or something close to it. And welcome back to Civil Procedure. Okay, so we come today to negotiation, which is arguably the single most important unit in the entire course. Because, as you all know, the overwhelming majority of cases will settle, right? And in fact, the majority of cases will settle through some type of negotiation process without even the benefit of a mediator or an arbitrator. And of course, the basic question that you probably already thought about, actually, I'm sure you thought about this in the legal practice simulation last year, is why do we settle our cases? And we had a participation question on that. And people identified most of the big ones, right? Settling, of course, saves money and saves time. This person is correct. It makes you competent in the sense that the rules of professional conduct identify negotiation as a core element of competence for a lawyer and impose an ethical obligation on all lawyers to consider the use of alternative dispute resolution and recommend it to clients in appropriate cases. So saves money, saves time. We also know, of course, litigation drains people's psychological resources as well. It eliminates the stress. A couple of people mentioned kind of the public interest, right? So not backlogging the system, and takes pressure. Someone said takes pressure off the court system. So that's true, right? I mean, we as taxpayers all want people to settle their cases, so we don't have to pay judges $350,000 a year to sit through a trial of every single dispute that people can possibly think of bringing to court. You don't want to say this to your client if you're trying to talk them into settling. Your client does not care about how much it costs the judge. But from a systemic point of view, that's obviously part of the public interest in settlement. There's a couple more that didn't really come through so much in your answers here, but we'll get to those in a minute. Okay. Now, settlement is often an argument or a debate which you have with your clients, right? Your client, the very fact that a client has retained a lawyer and instructed that lawyer to commence a lawsuit or to defend a lawsuit in the case of a defendant, that typically only happens after that person has exhausted opportunities, what they see as their opportunities to resolve the case without having to resort to law, right? I don't have a slide on this, but disputing is like an iceberg, and the overwhelming majority of disputes that arise in people's lives or in the conduct of business never come near the legal system. So the ones that get into the legal system in any way are the tip of that iceberg sticking above the water. And the fact that your client is in that tip of the iceberg that sticks above the water generally indicates that they feel that there is no opportunity to resolve their dispute without resorting to law. So that's why having this conversation is often a matter of persuasion, right? To persuade the client at various stages down the road to consider the opportunities for settlement. Okay, so let's look at a few more of the things that come into the decision about whether to settle. So the cost associated with the risk of trial. That's a big one, right? Risk inherent in civil litigation, right? Judges are unpredictable. The law is vague and ambiguous, as you learned by this point. Not only is the law uncertain, but the facts are also uncertain. And despite what will often be your client's strong commitment to the version of facts as they see them from their point of view, there's always factual uncertainty. And factual uncertainty along with legal uncertainty creates risk. Another thing that you got in that excerpt you read, the George Adams piece is this idea of possibility of greater advantage to both parties, right? And of possibility of creating solutions that that a court either is incapable of giving or just is unlikely to give. Can anyone give us an example of a resolution or a type of remedy that your client can get from a settlement that they would never get from any court, even on their best day? An apology. Courts do not order people to apologize. Does anyone know why? Why don't? Why will a court never order someone to apologize? Right. Yeah. I feel we might have talked about this a couple weeks ago. Anyway, people have got it. Section 2B, freedom of expression. So the apology is there. So Hajar mentions a raise, and that's probably true, actually. I mean, so a court can order a settlement, a monetary payment, which in one sense could be equivalent to a raise, in the sense that it's could be, you know, the present value of the income stream you would get over time if you were to get a raise. But yeah, they'd be unlikely to. They're unlikely to make orders that sort of have to be enforced over time. The thing about a judgment is that it's a sort of a momentary resolution, right? And because the system only wants to make orders that can feasibly be enforced, judges are very reluctant to make orders that reach far into the future and say, well, you know, the parties have to do this years from now, and they still have to be paying that, you know, raise at some point in the future. So you're not likely to get any type of resolution that reaches far into the future, like a raise. And then, yes, that's right. The possibility of a continued relationship through settlement, right? Very important in certain types of cases, unimportant in other cases. But litigation is toxic to relationships, right? And in some cases, even though parties have got to the point of entering civil litigation, there is a possibility of rescuing or continuing a relationship going forward. And that can be a personal relationship, or that can more commonly be some type of commercial relationship, which is mutually profitable for the parties. I don't want to oversell this point. You know, typically by the time pleadings have been exchanged, the prospect for a relationship has already been destroyed, in the sense that the level of distrust that parties have to get to before they get to the point even of issuing pleadings is toxic. But in certain cases, you can rescue that potential through settlement, particularly an early settlement. Okay. This is also this piece about the creativity, right? Remedies no court can give, and creative responses to mutual needs the courts are unlikely to have time to identify. This comes up often in family law and in cases involving custody and access of children, right? So for a long time, on every Wednesday night in every restaurant across the country, you would see fathers with their children, because there was a sort of standard custody and access order that courts happen to give, just as a matter of course, where the sole custody parent would, child would live with the sole custody parent, and the access parent, typically the father, would have access every Wednesday night, and then there'd be sleepover every second weekend, right? So that was kind of like an off the rack order that courts gave out as a matter of course, because they didn't have time, they didn't have the insight to sort of examine each family one by one and decide, well, maybe Thursday night would be better, or maybe it should be 3 nights, or maybe there shouldn't be overnights, right? Courts are pressed for time, and if they have an opportunity to sort of give an off the rack order, they're going to do that. But of course, there's 1,000 reasons why every Wednesday night and every second weekend is not going to be the optimal custody and access order for a particular family. And if you settle that case and you negotiate a parenting schedule, then it's more likely to be advantageous for all parties, because it takes account of the specific things going on in that family, right? Is that Does the kid have hockey on Wednesday night? And would Thursday night be a better night for everyone involved? Okay. So this is why we say, and lawyers will often say, that a bad settlement is better than a good trial, because of all these advantages that come with just settling. Privacy is one that I think several people mentioned. They mentioned not wanting to be in the news, get out of the media, especially in big cases. And even if there's no media interest in your case, then privacy is an issue, right? For many parties. Just having all these court people know about what's going on in your life or going on in your business. Just having the judge know, have the jury know about it if there is one. Having the court clerks, having the system, dip its hands into the private details of your life or of your business and of your dispute is distasteful to many people. Settlement can be completely private. Now, pleadings are public in a sense. Like, technically, the press will have access to all pleadings except in exceptional circumstances. But the further you go down the road, the more the system gets its hands on your life, the less privacy you have. The earlier you settle, the more quickly you get out of that exposure. So the immediacy of the benefits is another one that is worth identifying, right? So if you're on for the plaintiff and you settle, then your client gets the check right away, right? And if at any given point you decide to not settle and go on to adjudication, go on to trial, that means that whatever your client gets, they're going to get it later. Right? So the immediate benefits. A settlement delivers an immediate benefit, typically an immediate check for your client. Adjudication doesn't. There is a remedy that courts give to reflect the passage of time after. Let's pull on this. This is kind of a callback to something at the beginning. Okay, the scales are tipping in the correct direction. So prejudgment interest is the one we're looking for here. So that does exist as a way to compensate the plaintiff for the passage of time, but still, getting settlement delivers something right now, which is immediate and certain. For the defendant, on the other hand, like, the immediacy of settlement is also appealing, right? Because the longer you remain a defendant, the longer you have this kind of risk and uncertainty hanging over your head. And particularly in the case of corporate defendants, they want to get that risk off the balance sheet, so to speak. And as soon as settlement happens, that problem is there. So you can think of this in terms of a bird in the hand versus a bird in the bush. People have hopefully heard the expression, "A bird in the hand is worth two in a bush." Okay, so this is an expression that refers to the idea that something you have right now and is certain, it can be preferable to a bigger or apparently more valuable thing which is uncertain and delayed, right? The premise of the whole aphorism is that you want to have this awful little bird in your hand because you want to eat it or whatever, right? So it's something good, then the smaller immediate benefit can outweigh the bigger but delayed and uncertain benefit. And so the settlement is the bird in your hand. Now, of course, there's two problems with the birds in the bush. First of all, you might never get them, so that's the risk and uncertainty. And second, even if you're sure to get them, you don't have them yet, and you won't have them until some point in the future. Okay. So I think that's a good, probably enough to say about the expression here with the general arguments for settlement. Let's talk about settlement timing, right? So at what point in civil litigation can settlement occur? So let me ask you this. this case, do people remember this case? And can anyone tell us when this case settled? Yeah, during trial, and did anyone remember when in the trial? Very, very late, right? So you guys saw the trial in this case. So all of that stuff happened, all the examination of the witnesses, opening and closing statements. So after all the closing arguments were done, just before the jury issued its verdict, right? So a very, very late settlement. And that's fine, right? You're not penalized for, having wasted the judge and jury's time. And in fact, they weren't necessarily wasting the judge and jury's time, because it could be that the only reason they were able to settle is because, not until trial did they have the chance to really see and weigh each other's evidence, and for the plaintiff defendant to change their positions and decide change their view of what they'd be willing to accept in a settlement. So that being said, both of those clients probably afterwards were less than completely happy, because if you're Jeff Caudill or if you're Scottsdale Insurance, you might well be thinking, well, if we settle this case, why couldn't we have settled this case before we spent $50,000 on legal fees and all these months of time? But nonetheless, they had reasons to settle, and it was still many of the benefits, some but not all of these benefits of settlement are still available to you at that very, very late point, right? You still avoid the risk. You don't really avoid any of the cost, right? Because all those costs have pretty much been paid. You still have possibility of creating a settlement which is more creative and more responsive to both parties' needs than what the judge would offer. Yeah, so it's fair to say that settlements avoid Pyrrhic victories if they happen early enough. So a Pyrrhic victory, people recall, this was, I think, the very first or second lecture, is where you accomplish your goals, like you win, you get a favorable adjudication, but the time and money and aggravation which it cost you to get to that favorable victory, that adjudication, exceeds the value of what you won. And so that's the reason why, even if you're completely sure that you're going to win, not that you ever can be, but if somehow you were, it's still advantageous to settle, assuming the terms are right. Okay, so this is a very late settlement. You could go even later than that, even after the case has been decided. Even after the jury verdict and after the judge's order, there's still something to settle. What is that? Costs. Yes, exactly. There's still costs to settle, because we know that costs are kind of this bonus round that occur after adjudication of the main event. In addition to costs, there's one other thing that parties might want to settle. What right does the losing party still have after the judge has issued their reasons in an order? Because there's a right. Appeal. Exactly. That's right. Cost and appeal are both things that you can settle after the judgment. Both rights that the losing party has, that will be worth, appeal is a right the losing party has that it's worth something to the successful party to get the unsuccessful party to give that up. Okay, so that's sort of how late settlement can occur. Let's talk also about, where was it? I think there's a question on the earliest point. Yeah, the earliest point at which you can settle a lawsuit on behalf of your client. And 63% of you got the correct answer here, right? That as soon as your client gives their informed consent to the terms of a settlement, you can settle the case. Which means that, if a client walks into your office for the first time for an intake interview, and perhaps they haven't, for some reason, discussed resolution with the other side before they saw you. There are cases in which you can advise them of their rights, and they're willing to think about settlement right away. Now, informed is an important word here, insofar as your job as a lawyer is to tell the client what their rights are. Every settlement involves giving up in principle. Almost every settlement, there's some element of compromise involved, and your client cannot consent to a compromise unless they have a sense of what the law might grant them, right? So that's your job, and that's how you inform their consent. But this can happen at any stage of the civil litigation process, and it's nowhere written down that you have to file a statement of claim or finish the discovery process before you do that. Now, that being said, most cases will not settle before pleadings. Pleadings are where parties kind of define what they want from each other and state their legal position. So if you're on for a plaintiff, especially if in the typical case where the plaintiff has had some discussions with the defendant before they came to you, that defendant is not likely to cough up anything beyond what they offered beforehand until that defendant has seen at least your statement of claim and got a sense of what their risk and exposure might be. And likewise, if you're on for a defendant, it's an unusual plaintiff who is going to accept your settlement offer, which they rejected before hiring a lawyer. Because once they hire a lawyer, they kind of committed to a process and they paid a retainer. So typically, things are going to happen a bit later in terms of settlement. But the real point here is that you need to be thinking about settlement from day one, right? From the initial client consultation onwards, you need to think of every step you take in terms of how it's going to set your client up for a favorable settlement, because that's almost certainly what's going to happen. That's almost certainly how your case is going to end. That's in most cases. So they talk about in the Adams book. They talk about litigation, right? Litigation being the idea that you take these litigation steps while at the same time pursuing a negotiation track at the same time, and the litigation steps you take build your successful settlement, and they do so, but primarily by convincing the other side. Right, by showing the other side the merits of your client's factual and legal grounds, and convincing the other side of the risk which they would face if they don't come to the table with an acceptable settlement offer. Okay, so these are obvious. The advantages of early settlement are obvious. Can anyone recall the rule? Anyone throw up in the comment the rule which explicitly rewards parties for making early settlement offers, that turns an early settlement offer into money in the bank if your offer is early enough and generous enough. Okay, it is within costs. And anyone remember the specific one we're looking for? Yeah, so it's in Rule 49. 49.10 is the one we're looking at here, right? So remember, this was back a couple weeks ago, where an offer which is early enough and generous enough and which is not accepted, right? If you beat that offer at trial, that is to say, you get a better outcome at trial than what your offer was offering to the other side, then you get this bonus cost regime, right, where you get more cost than you otherwise would. So that kind of formalizes it. So lots of reasons to settle early. Some risks from premature settlement, right? There have been ethics cases where lawyers settled too early, and the problem with premature settlement is that you may not know what you're giving up, right? And lawyers are very cautious, perhaps excessively cautious, but understandably cautious about settling before discoveries, insofar as they feel that they don't know what they're giving up. They don't know what's in the black box of discovery, what the facts will turn out to be. And then, of course, there's also some less savory, some illegitimate reasons why settlement so often happens late, why settlement so often happens on the court steps. What about fees? We've talked a little bit about lawyers' fees structures and how we charge our clients. How might different types of legal fees create incentives for lawyers, like sort of selfish reasons for lawyers to settle early or settle late? Okay, so what about a contingency fee? Contingency fee, people recall, is a fee which varies based on the degree of success you obtain. Typically, it means taking a percentage of the settlement or judgment. The sooner they settle, the sooner they get paid. Okay, so that's true. Well, that's true with contingency fees. Yeah, with contingency fees, the lawyer is going to take their fee from the settlement proceeds. It is said that contingency fees sometimes incentivize premature settlement, right? Where the lawyer for the plaintiff will fold early and they'll accept an offer which is too low, because not only because they get the money right away, and especially this is like an issue with small firms and solo practitioners, right? So there's cases where like you'll have like a solo practitioner who's maybe working in a small town. And the lawyers are generalists. They do a little bit of everything. And someone in that small town has a terrible car crash, right? It's a young person, and they're going to be entitled to a major settlement from an insurance company, right? Tens of millions of dollars, perhaps. And but the insurance company is defending it vigorously, and the small practitioner, right, the solo practitioner, takes it on a contingency basis, and to push that to trial, right, to hold out against the insurance company, to invest the 4 years of their own time, and to invest all of the costs, everything you have to pay to get expert evidence and so on, is a huge financial commitment, right? If you're a sole practitioner and you don't have any partners to draw on, and you're trying to take one of those cases up to trial or carry it until you get the acceptable offer from the insurance company, you have to borrow a lot of money and take on a lot of personal risk. So there's a phenomenon where lawyers like that will sometimes recommend premature settlement, even when it's not necessarily in the client's interest to do so. So that's an interesting issue that comes up with how the market is structured for injury services, and why we want to have referral fees and other mechanisms that encourage those expensive, risky cases to perhaps be referred up to better established plaintiff side firms which have the resources to hold out and get that good settlement. So that's contingency. What about time-based fees? How might a time-based fee retainer affect the timing of settlement that lawyers are going to recommend? If you're being paid by the hour and you're strictly in it for the money, looking out for number one, don't really give a damn about the client, what kind of settlement? When are you going to promote settlement? That's right. So Natalie and Andrew have it here, right? So there, the risk is the opposite. Time-based fees, to the extent that lawyers are self-interested, are going to lead to post-mature, right? Excessively delayed settlement, not in the client's interest. Okay. So what you read for today primarily was an excerpt from this book, I love this book. I know the book, the excerpt was long and kind of dense, but I really like how I like for you to have at least one example of kind of civil litigation scholarship, which is what this book is, right? And I think the way he approaches it kind of shows the wealth of considerations that that are at play when people are negotiating things, and shows how kind of the scholarship around negotiation has evolved over time. Okay, so Adams talks about what distinguishes settlement legal dispute settlement negotiations from other type of negotiations, right? Because negotiations are everywhere in life, and this is just one particular type of it, right? If you are moving in with a roommate, you may negotiate chores and who's going to pay the utility bills, right? If you're starting a new job, you might negotiate salary, growing up, we all negotiate, and children can be remarkably effective negotiators to get more of the things they want from their parents and to avoid doing things they don't want to do. This is my life right now, at least. So Adams talks about what distinguishes legal dispute resolution negotiations from other types of negotiations. Can anyone give us a sense of what this is? What makes these negotiations special? He talks about it right at the beginning. If you're in if you're watching a negotiation between people dickering over the price of a car, or negotiating chores or something like that, versus dispute resolution, they're distributive in nature. Yeah, he uses that word distributive, doesn't he? Although to an extent, all negotiations distribute something. It's more a matter of what they're trying to distribute is what distinguishes these dispute resolutions. And it's in particular this here, right? So he says these disputes usually center on the distribution of losses arising out of an accident or breach of contract, right? So that's a distinguishing feature here, that people litigate when something has gone wrong, and they're trying to divide the losses that result from that thing that went wrong. And that means also that they are backward looking, right? They are, if you're negotiating a salary, or you're negotiating, how to start a business with your, partner who's starting a business with you, you're talking about the future and what's going to happen in the future. You're typically trying to maybe assign some risks, but also divide gains when you're doing that. Dispute resolution, backward looking, and it's about the division of losses. Another thing he talks about is the fact that in legal dispute resolution negotiations, the parties are thinking about a judge. Why are they thinking about a judge? Given that if you're negotiating, you're trying to avoid adjudication. But nonetheless, in the back of your mind, and perhaps even in your explicit communication when you're negotiating dispute resolution, you are thinking about a judge or judges and what they might do. Why is that? And how does that create a distinct characteristic of legal dispute resolution? Whether you get a better judgment in trial. Yeah, that's right. That's right. So you're thinking parties negotiating legal dispute resolution are making predictions about what a judge might do, right? Because that's typically their alternative to a negotiated resolution. And this is an important thing that distinguishes this type of negotiation, right? Because if you're trying to sell me your 1988 Honda Prelude, right, with those extra easy to push power window buttons, and you want $1,000 for your Honda Prelude, and I counter offer $500. There's no right answer as to how much that car is worth. There's no third party who's going to tell us how much should be paid for the Prelude. By contrast, if you and I are trying to resolve our civil litigation, avoid going to court, and we fail to reach a resolution, there is that third party. That judge is out there who will impose an answer upon us. Therefore, we're going to be these predictions are in the back of people's heads when they're talking about legal dispute resolution. And that's you may hear the term shadow of the law, right? And we talked about the idea of the shadow of the law when we were looking at the Hriniak versus Malden case in summary judgment, right? Do you remember this, where Madam Justice Carrick-Stannis for the Supreme Court of Canada in Hriniak versus Malden said that people settle most of their cases, but they need to settle. They want to settle in the shadow of the law, which is to say they want to have plausible, somewhat accurate predictions about what a judge would do were they to get it to trial, right? And so the Supreme Court said in that case that that's why we need things like summary judgment, because parties have to have access to adjudication if the settlement process is going to work. Because if no one knows what a judge would do, and there's not insufficient certainty in the law because of insufficient precedents, then what are we supposed to settle on, right? How are we supposed to guide our expectations when we go into that settlement negotiation? So we want settlements to occur in the shadow of the law, and not to occur in the shadow of power imbalance, right? Because it's a very real risk that what happens in settlement negotiations will depend on who has the deeper pockets, right? Who can hold out longer. We were just talking about that situation where you have a sole practitioner, a lawyer, operating on a contingency basis, so they have no money coming in, and they're trying to hold out. They're trying to negotiate a resolution against an insurance company, which has effectively unlimited resources. And that power imbalance and the deeper pockets on the insurance company side are a powerful source of strategic advantage, and a reason why the plaintiff may give up a lot more than the insurance company does in that settlement offer. So in terms of the public policy of trying to create the space for settlement to work, we're trying to create a system where parties will settle in the shadow of the law and not in the shadow of power imbalance and disparate resources, which so often characterize civil litigation. Okay, so that's probably enough theory for now. Let's get to some law. And the law I wanted to talk about is Rule 49, which you read for this week. So this is, we've already seen parts of Rule 49. Right? We saw 49.07 sub 5, which is about settlement privilege. And then we saw the parts of this that pertain to the bonus cost regime. But the rest of 49.02, 49 that you read for today is basically how settlement offers work and kind of the contract law of settlement. So Rule 49.02 says that you can make a settlement offer, and there is a form. There's Rule 49, Form 49A. Anyone remember the website where we get all the forms? Throw that up so people can remember if you happen to remember. Ontario Court Forms, bingo, ontariocourtforms.on.ca. So there is a form. And then there's also a form for accepting a settlement offer over here, 49C. But what you need to remember is that these forms are not obligatory, right? You can settle a civil dispute without any type of form or formality, which is why the rules say that you may you use this form. They don't say that you must. And that's because a settlement is simply a contract, right? And in first year, you presumably did all those great old cases about, how a contract is formed and what's necessary to form a contract, right? So you have to have offer, you have to have acceptance, and you have to have consideration, right? And you don't need formality. You know that oral contracts are contracts, and any type of communication in which an offer, a clear offer and a clear acceptance on a defined set of terms can be seen, and there's compensation, and consideration rather, will count as a contract. And that's true of settlement contracts as well. So, okay, so let's think about settlements as contracts. What is the consideration in a typical settlement contract? Right, because you know from 1L that our law will not enforce just any promise. It requires that consideration be present. Okay, so ending the litigation, giving up the right to sue, right? So those are all. So which side would offer those things? The plaintiff. That's right. So from the defendant's point of view, that's the consideration the plaintiff plays. The consideration coming from the defendant's side of the contract will typically be money, but it may be various other things as well. So as long as your settlement passes muster as a contract, according to the sort of 1L contract law rules, it's a real settlement, whether or not you use any forms. So that being said, there's reasons why you might want to use these forms, right? It's clear evidence of an intention to offer. So if you want it to be absolutely clear to everyone that as a plaintiff you have offered settlement, Form 49A kind of puts that beyond dispute. We know that for purposes of Rule 49.10, our bonus settlement regime, those offers to settle have to be served. So particularly if you're going to try to take advantage of Rule 49.10, you're going to want to have a written settlement offer on one of these forms. So that's all there, but none of this alters the basic reality that these are contracts. Now, that being said, there are some terms in Rule 49 which do alter or may be seen to change the law of contracts, right? So 49.04 sub 4, an offer may not be accepted after the court disposes of the claim in respect of which the offer is made. Rule 49.05, an offer to settle shall be deemed to be an offer of compromise made without prejudice. So what this means is that you, by offering something, have not given up the ability to argue in court that something else should be the case. So it's an offer of compromise without prejudice, and you can. So it's kind of like privilege. I mean, privilege, as I've said, is about shielding facts or documents from disclosure, which could otherwise have to be disclosed. This is more about the position you can take in court, right, and the position you can take in subsequent litigation. Okay, so closely related to privilege is what we have here, right? So 49.06 is basically imposing this cone of confidentiality over settlement negotiations, and we talked earlier about the reasons behind this. We also know that settlement offers can't be just in pleadings. We talked about that in our pleadings unit, and if you refer back to your notes there, you'll see all of the policy considerations that underlie this. The long and short of it is that the law wants to encourage settlement negotiations, and we don't want parties to fear making settlement offers or discussing settlement because doing so will undermine their case that they want to make in court as the court process continues. Okay. And so this is basically just a refresher, but you remember in privilege, right? This is a specific, one of our four types of privilege. One of the four shields which can prevent something from being disclosed is the fact that it relates to a settlement discussion. Okay. So, a couple of things about settlement. Settlement can be partial or complete, right? You can settle if you make 3 or 4 claims in your statement of claim at any point along the road. You can settle 2 or 3 of them, or just one of them. Um, Parties are also encouraged to settle the procedural disputes that arise during their litigation. Enforcement is also kind of a separate issue. So you can get a court judgment, but then you can be in a dispute over, whether we're going to be garnishing your wages or not. So, if you've lost your case and you know that you owe $10,000 to the plaintiff, might say, okay, well, now we're going to enforce that by being garnishment proceedings. You can settle that too, right? And maybe the settlement is, I'll give you $9,500 right now, cash on the barrelhead, and in exchange, you agree not to garnish my wages. So everything can be settled. Okay, so let's switch back now to talk a bit more about the theory of settlement negotiations, drawing on Adams. So George Adams says that there are two modes of negotiation in legal dispute resolution, right? The first of which is positional negotiations, and the second of which is interest-based, also known as integrative. Okay, so let's say, imagine that you're on for the defendant, right? And you go through the pleading stage. You have your discovery. Your discovery dispute is your motion is resolved. And let's say you, on for the defendant, move for summary judgment under Rule 20. Now, summary judgment, hopefully people recall, is a form of disposition without trial where the moving party can have their opponent's case completely blown out of the water and win completely at an early stage. And summary judgment is the form of disposition without trial, which is substantive and evidence-based, and may even include oral evidence and some trial-like features. Okay, so you've brought this motion for the defendant. If you win, then your client wins completely. If you lose, then the parties will probably continue on to trial unless they can settle afterwards. Okay, so you're bringing your summary judgment motion. Before it's going to be heard, you filed your summary judgment materials. You get a call from his lawyer, and they say they would like to discuss settlement with you. So if you think back to her statement of claim, this is her statement of claim. She wanted a few things. She wanted different types of damages, and she also wanted a declaration that the defendant discriminated against the plaintiff on the basis of the plaintiff's sex. So your client says to you, we're not making this declaration. We're absolutely not going to be making any public statements to this effect. However, we are willing to discuss a monetary settlement, right? Paying something to this plaintiff to resolve the case. In exchange, of course, for dropping the suit. And the plaintiff's lawyer tells you that they are amenable in principle to a negotiated settlement if the number is right. So she's willing to walk away without the declaration if she gets the right size check. So the question is now, can we do a deal? And if so, how much? What would that check say? So let's think through this in terms of this distributive or positional negotiation, right? The first of the two models that Adams discusses. And positional or distributive negotiations happen when people are trying to divide scarce resources, right? And here we're in a distributive or positional type case because the parties are just talking about money, right? What's the number on that check going to be? So your client says, look, we want to pay as little as possible, obviously, but we're willing to pay up to 3.75 million. So he says, we're willing to pay up to that, absolutely have to. So this is what we call the resistance point. The resistance point is defined as the least favorable outcome that a party would still prefer to walking away from a settlement negotiation or mediation. And so least favorable because that's the highest that they'd be willing to pay. Of all the numbers on that check that they'd be willing to write in order to make the case go away, this is the highest number. So what sort of factors, what sort of considerations would lead to this number being what it is? What sort of reasons might cause this number to be 3.375 million instead of 5 million or 200,000? Yes, the merit being specifically what they predict a judge might order. Okay. What else? Because it's not just that, right? There's two parties might have exactly the same prediction but have different resistance points. Lawyer costs here, and how would that change it? If your legal fees, like if your lawyer is $800 an hour instead of $300, if your lawyer is more expensive, will that make your resistance point higher or lower? Yeah, it's going to increase it, right? And we'll see why in a second. But it has to do with the fact that the more your lawyer costs you, the more your lawyer costs you, the more it's going to hurt you to keep on litigating. The more it costs you to keep on litigating, right? And the more it costs you to keep on litigating, the keener, the more eager you are to get out of the litigation. And the more eager you are to get out of the litigation, the more you're willing to pay to do so. So Sarah, maybe Sarah, you might be assuming that you're assuming that a more expensive lawyer is more likely to succeed. Hopefully, I mean that might be the case, but all else being equal, holding your prediction of adjudicated outcome constant, if your legal fees are higher, then you're willing to pay more to get out of it. Okay, so we've identified a couple things that affect what this resistance point are, right? So your prediction of adjudicated outcome, your legal fees, how much you're paying. What else? What else shapes this resistance point? Maybe think back to this slide here, right? So about the reasons why people want to settle. What else? And the more keen you are to settle, yes, okay. So the bad media, like how much your privacy is worth, basically, right? The longer the case goes on, the more your privacy is infringed, and the worse that feels for you, the more you want to settle, and the higher resistance point is. So all of these things can move in different directions. One of them is just risk aversion, right? Even if two parties predict the same adjudicated outcome, one party might be much more risk averse than the other, right? Some parties accept a roll of the dice, other parties hate a roll of the dice. And the more risk tolerant you are, does that make your resistance point as a defendant go up or down? If you're a risk-taking personality, that's right, makes it go down, right? Because it makes you less keen to settle. Okay, lost my place here. Okay, so all these things shape the resistance point. One thing that's worth noting here is that the value what you said in your pleadings, right? Like, remember those numbers at the beginning where parties throw around, oh, that's $12 million. You pick these big round numbers often for effect. That doesn't really matter when you get to the point of positional negotiation, right? Because a party is in no way held to this, right? So switching to the plaintiff side of this, if she settles for $6 million, she's not in any kind of trouble, right? That's not a problem from anyone's point of view. So the pleadings kind of fall away at this point, and it's all about these factors that we're going to identify. Okay, so resistance point is important. As a matter of strategy, it's very helpful to know your resistance point when you're going into any negotiation, including negotiations that do not pertain to legal dispute resolution, right? If you're going into a negotiation to buy this 1988 Honda Prelude, it's very helpful to formally identify what's the most you'd be willing to pay, right? Because when you're there on the lot and you're falling in love with the sexy yellow paint job and the easy to operate power windows, you don't want to get carried away and end up paying $5,000 for it, right? So it's helpful to have your bottom line firmly in mind. Same is true of a legal dispute resolution negotiation. You want to know this, and whose decision is that to make? The resistance point that you carry into a distributive negotiation. Bingo! It's the client's decision, and the client makes that decision with the benefit of your advice and your information. Okay. So I want to talk about litigation risk analysis, which is one way to identify what your resistance point should be. So what your least favorable outcome you'd be willing to accept should be. Okay, so how do you do this? It's a process with several steps, the first step is to identify the alternative outcomes. Think about all the different ways this case could turn out. So you brought a summary judgment motion, and now you're discussing settlement. The summary judgment motion has not yet been heard. So here we are having our settlement discussion. Either we'll settle or we won't settle. If we don't settle, we go to the summary judgment motion hearing. It could be granted to us, in which case the case is over, we won, or it could be refused. If it's refused, then we'll go to trial, and at trial, we could win completely, or we could lose. If it does get a judgment in her favor, the question is, what are her damages going to be? And they could be low or medium or high. Second step is to assign likelihoods to these outcomes. So how likely are all these different things to happen, right? Maybe the summary judgment seems like it's a toss-up. It's like 50-50 whether we'll win or not. So we put 50% here. If we go to trial, we think it's not so good. So we think she's actually got a 75% chance of winning there. And then if she does win, we'll say like the medium level damages are most likely. The high and the low estimates of her damages are just 20% each. The third step is to value these outcomes, right? So valuing the outcomes means how much would all these different outcomes cost us as the defendant? So if we go all the way down this chain and she wins, but she just gets the low damages, a $6 million award, that'll cost us $6 million there. If she gets the median level, we're going to have to pay $8.5 million. High would be $12.5 million. We're also going to value, put a price on this, right? On the outcome where we win the summary judgment, and we put a price on the outcome where we win the trial judgment. So let me ask you this. Why aren't these numbers zero? Why isn't this zero and this zero? Because these are outcomes where our client wins. So not exactly cost, right? Because in terms of cost awards, our client would presumably be entitled to some sort of cost award, right? If you win summary judgment, you're entitled to a cost award from the plaintiff, likewise at trial. Yes, Catherine's got it. It's legal fees, right? We know those cost awards do not cover your entire legal fees, right? The partial indemnity cost award, 50 to 60%, which means that your client is still eating 40% of what they had to pay you to get there, right? And if they had to pay you 200 grand to go to trial, and they win, they're still out 100,000. And of course, this $100,000 cost is bigger than this because there are higher legal fees to go through the summary judgment and go through the trial compared to just having this. Okay, so these numbers over here, these costs include both the $6 million estimate, that value of the wins against the low judgment, includes both the damages we'd be ordered to pay in that scenario and the legal fees our client had to pay to get that far down the road. Okay, so if we settle now, we can avoid all of these risks. But exactly how much is it worth us? Is it worth to us to avoid all these risks, right? Because that number is going to be our resistance point. How much is it worth to us? The greatest number that we'd be willing to pay to avoid all of these different worlds of pain. Okay, so this is where it gets kind of complicated and mathematical. But you calculate the expected value. It's called the expected value of the case by multiplying the likelihood of these outcomes by the exposure if that outcome transpires. Okay, so what's the outcome of this $6 million hit transpiring? Remember, we're looking at this from the defendant's point of view. So this means this is the scenario we're thinking through in our mind where, okay, we don't settle, we go to settlement summary judgment, we lose summary judgment, we lose the trial, and then the judge makes this low value damage estimate. And the likelihood of getting there is 50% times 75% times 20%. Right? So how likely is it that we'll get here? Because all these different things could happen, and this is the likelihood of this outcome happening, right? So it's ends up being 0.075%. So it's there's a 7.5% likelihood of getting to this box. Right? Because first we have to get to this box, which is just 50-50, then we have to get to this box, which is 75-25, and then it's 20 here. So the expected value of this hit is this number, right? 0.5 times 0.75 times 0.2. Okay, and then we do the same thing with all of the other outcomes. Right, so the chance of this happening, this medium damage box happening, is 0.5 times 75 times 0.6, and then this over here is the chance of this happening, 0.5 times 0.75 times 0.2. And then we also assign an expected value to these outcomes and to these outcomes, right? So, and if you add all those things up, you get 3.375, right? So it's a way to mathematically calculate how much your client should be willing to pay to avoid all these risks. You're on for the defendant, so you're trying to avoid all these bad things happening. This is why your client is talking about in settlement in the first place, because none of this is good stuff, right? This is all bad in different ways for your client, for the defendant. But the question is, how bad is it? How much does it cost? And how likely are those things to transpire? Yes. Okay. So some people are struggling with this still. Okay. So let's maybe it's helpful to think about this from the plaintiff's point of view as well, right? So for the plaintiff, right, because this is something which you can do for both the defendant and for the plaintiff. So the plaintiff, she's claimed all these damages. If she settles, she gives up the chance of getting a damage award, right? Because in a settlement, she's gonna drop her suit, and so if she does so, she loses the chance of getting these things. So how much? What's the least? Because for the plaintiff, the resistance point is the smallest number that she'd be willing to accept to walk away from her claim. And so for her, that number, that resistance point, is based on her prediction of how likely these things are to happen, right? Because if she thinks, suppose she's going over her submissions on damages, right? So she's thinking ahead, right? Right now we're still back here, we're still before the summary judgment motion. She's thinking about what might happen. And she's thinking, well, if I can prove the discrimination, if I can prove the breach of promise, and I completely make out my case on liability, I'm then going to have to make out my case on damages, right? So for the plaintiff's point of view, she's thinking, well, to make my estimate, to prove high damages, I have to prove that that I've lost a huge amount of lost income. So if she decides that she's more likely to get those high level damages, then this number goes up from 20% to say 25 or 30%. And that is going to increase her resistance point, right? Because she now requires more money to give up her chance of winning that. And so the likelihood of these things transpiring affects the resistance point. So it's not an exact science, right? So all of these numbers are guesswork. Basically, like you'll never know exactly what the likelihoods of the different outcomes are. So there's software to do this. I wanted you to know about this. You're not going to have to do this on the exam, but it's something to keep in mind as a tool which is out there for you as litigators. And it's a way to sort of think about how your predictions of adjudicated outcomes shape what's going on. And litigants, even if they don't do all this math, they are going to think about this, right? Like you want to at least think through the scenarios before you do this. But before you settle, before you decide what your resistance point is, you've got to think about all the things that could happen in the case. And if not mathematically, then at least informally try to structure your thinking on the basis of your prediction of what might happen. Okay, so positional bargaining. Positional bargaining occurs when you have a monetary dispute. Parties, it doesn't have to be monetary, it can be any quantifiable resource. So in high conflict parenting cases, this can even be about hours that the child will spend with mom and dad, right? And dad will say, I want 20 hours. Mom says it should be only 10 hours, and it can be just as positional in sort of choosing that number of hours per week. But most often we're talking about money. And resistance points are very important. The resistance point, I should say, so it can be structured by litigation risk analysis, or it can be quantified in that way. But the reason why your resistance point is what it is depends on the advocacy that the other side is engaged in, right? So in this case, the reason why they got to 3.375, the reason why they see risk in this case is because of the advocacy which the plaintiff has engaged in, right? So it's not accurate to think of kind of litigation and negotiation as two things that happen on separate tracks. The efficacy and the power of your litigation and of your advocacy, of your pleadings, of your discovery strategy, and so forth, shape the resistance point of the other side. Because if the plaintiff had not brought the case and hadn't done what she did, then they wouldn't see any risk, and the resistance point would be much lower than it is. Same is true for how the defendant's advocacy has shaped this. Maybe if the defendant did a lousy job, then that might mean a much higher resistance point than she otherwise would. Okay, so in a purely positional negotiation, your goal as a lawyer is to get a settlement which captures as much of this contract zone as possible. And the contract zone is simply the area between the resistance points of the two parties, right? So here it's 2.2 million up to 3.375. So you can think of this as a pie, right? This is people talk about getting the largest slice as possible of the pie is sort of what positional bargaining is all about. So there's various tactics that play into this. Who can give us a positional bargaining tactic? Something that you would do, something that people do when they're trying to capture as large a slice as possible. And this would apply just as much when you're haggling over the prelude. Start with the max, okay. So what do you mean by the max? Yes. So an aggressive opening offer, right? So aggressive would mean your client is willing to walk out with anything more than 2.2 million. You don't start by asking for 2.2 million. You start by asking for 5 or 4 or some number more aggressive than the resistance point. Likewise, if they're willing to walk out having written a check for up to 3.375, their initial offer would be something much less than that. Okay, what else? And so Adams talks about this quite a bit, page 39 and after. Other things that people do in positional bargaining situations. Has anyone ever haggled over a used car and starting with the merits of your side? Okay, yeah. So advocacy is there, right? Advocacy occurs. You remind the other side of the strength of your case, and you perhaps throw cold water on some of theirs. Expiry dates on the offers, right? So that can be a way to pressure the other side to accept. Potentially use emotions. There's acting is involved in positional bargaining, right? If you can convincingly act like you're outraged by the ridiculous offer the other side has put on the table. A good cop, bad cop. If you have the benefit of two people. What else does Adams talk about on page 39 and thereafter? Yeah, take it or leave it. You can say that your offer is your last offer. Okay, great. Kelsey says, don't let anyone know how low you're willing to go. In the case of the plaintiff, right? This applies to both sides. It's called concealing your resistance point, because once the other side knows your resistance point, you've pretty much given up any hope of capturing the contract zone or capturing a share of the contract zone, because they know what your bottom line is. So you want to conceal your resistance point and perhaps even lead the other side to believe your resistance point is something different than what it is. Because if you're on for the defendant and you can somehow get the plaintiff to believe that your client really won't settle for anything more than 3 million, then that's advantageous. Now, the ethics of negotiation are complex, There's differences of opinion about, about misrepresenting or actually lying in negotiation. Technically, in Ontario, it's not unethical for a lawyer to lie about the resistance point in a negotiation. In other places like Alberta, for example, that is a breach of the rules of professional conduct. But anyway, certainly, bluffing or implying your resistance point is different than what it is. What about so it's an ethical question that we don't have time to get into, but basically, if you're asked directly, you certainly don't have to reveal your resistance point. It's maybe a little bit closer to the ethical edge about whether you can lie in response to that question, but you certainly shouldn't reveal it. Okay, so a couple other things that were in the reading. So storming out, right? Leaving and with a big show of anger is something that's sometimes used. Preconditions, non-negotiable terms, saying we're not even coming to the table unless you concede X and Y before we get there. And this is all stuff that you'll see, like when Donald Trump is trying to bargain with North Korea about dropping their nuclear arsenal. It's the same stuff, right? Or collective bargaining in with the hockey union. It's all the same stuff. Natalie refusing to make the first offer set there as well. Another side thing is offering the opportunity for a face-saving concession, especially if the party has taken a public stand, but you think they might want to back down from that, then maybe there's things you can do to make it easier for them to do so. Adams talks on page 42 about the commitment tactic, where you basically commit yourself convincingly to an advantageous outcome, right? So if you you say, well, I think I would be a completely incompetent lawyer, and my client should fire me if I settle for anything less than $100,000. Right? That's a commitment tactic, because you've now made it and you've shown to the other side it would be very embarrassing and damaging to you personally if you do settle for anything less than 100,000. And if that's made publicly, that can sometimes be effective. Okay. So this is all potentially effective, but also very dangerous, right? And it's dangerous because it tends to destroy trust, and it's high risk. And it can lead to negotiation breaking down completely, right? Because while you're trying to get a bigger slice of this pie, you have to bear in mind the other side can take away the pie completely, right? And can deprive your client of all the benefits of reaching a settlement. So this stuff has a place, but it's also dangerous. Trying to determine the other party's resistance point and concealing your own resistance point are basic, essential practice. But the rest of this stuff is not, and can be quite dangerous. Okay, so that's positional bargaining. There's not always a contract zone, right? If the party's unable to, or simply not willing to pay any more than 1.75 and accept anything less than 2.2 million, then there will be no settlement, so long as the parties are sticking with positional bargaining, because that's the definition of resistance points. So if this is the case, right, and if this emerges in your settlement negotiation, does that mean that you have no alternative but to go to trial? No is correct. So what else can happen? Arbitration is an interesting idea, right? So we know that's privatized judging, where you assign the party to the case to another trial. And Andrew is also correct, right? You go back on the path of litigation, right? So in this case, you might have your summary judgment motion, or you engage in more advocacy, and it's the process of advocacy, all the things we've been talking about, which shift the other side's resistance point. And perhaps a month or two down the road, maybe after there's a motion or some further discovery happens, a contract zone may emerge. Okay, I think we don't have time to talk about the integrative piece at the moment. We'll leave that for Thursday, I think. And thanks for being with me, and I'll look forward to seeing you on Thursday.